Anyone who's raised capital privately has probably at some point faced this question of how do I get past 35 non-accredited investors? Because under Regulation D 506B, there's a limit of 35 non-accredited investors. What if I can't? What if I need more than that? So I'm going to break down a little bit on one way that you can avoid that legally based on some recent changes. So let me share my screen and I will show you exactly what I'm talking about. All right, how to bring in more than 35 non-accredited investors. So what are some of the legal issues involved in raising capital? I have other slides or other videos on this that talk about all the different federal and state regulations and laws involved. One of the ones we're going to talk about today is the Securities Act of 1933, either registering a security or finding an exemption. So what's one of the main exemptions that's used? About 94% of all capital, according to the SEC, is raised through private capital, that is Regulation D 506B. And that's an exemption to where you don't have to register your stock or whatever it is with the SEC. And under 506B, you can raise an unlimited amount of money. In the past, there were certain limits on B, C, like there used to be a different breakdown on 506, and 505, 504. Now it's 506B. That's the main one. Unlimited amount of money, 5 million, 100,000, 200 million, whatever it is. You cannot generally solicit or advertise. It has to be a private offering. And you have to have a pre-existing substantive relationship with your potential investor, meaning you had to know them before the offering. And you have to know a little bit more about them than just, this is my neighbor Bob, and I've lived next to him. You need to know a little bit about, are they somebody who can protect their financial interests and invest in this without it destroying their life and understand the risks of investing? And you can't go outside of those pre-existing substantive relationships, or it's considered a general solicitation. Can't advertise on social media or anywhere else. If you do, you are allowed to under 506C, but what we're talking about here is 506B, and which is one of the most common exemptions. You can have an unlimited number of accredited investors. So what is accredited? It's someone who has over $200,000 a year in salary over the last 2 years and an expectation that they're going to continue to make $200,000 a year. Or if it's a couple, $300,000 a year for a married couple. Also, the other test is, do they have over $1 million in net worth, not including the value of their house? So you can't take your primary residence into account. It has to be other things. And that's the main test people look at for individuals. There's about 17 different definitions under Rule 502, 501 of the definition of accredited, but that's the primary one people look at. So not everybody makes that much or has that much net worth. So what do? 506B, you can bring in people who have some level of sophistication, a sophisticated investor, but they're not necessarily the level of accredited. We just call them non-accredited investors. But 506B says you can only bring 35 of those non-accredited investors in. So, okay, well, if the non-accredited investors are the main source of investment funds and I can only bring in 35 and maybe they can only write a $10,000 check, I'm limited to not a whole lot of money that I can raise from those non-accredited investors. So one way that you can bring in more than 35 non-accredited investors and stay under the exemption for 506B, Rule 152. So there's a number of different rules in the regulations under the Securities Act that discuss things like integration. And what integration means is when you have a securities offering, you do an offering, meaning you're raising capital by selling stock, a security, or an interest in an LLC or limited partnership. You're offering that to people to buy, to invest. And so that's an offering. Now, once that, like you have that offering, and let's say a year, 2 years from now, you want to raise more money, you do another offering. Well, is that first offering part of the second offering? Are they considered integrated? Now, the old rule used to say there has to be 6 months in between, at least. So if you did one offering, you had to terminate it, stop raising money, wait 6 months, and then after 6 months, you could potentially do another offering. Otherwise, if you do one offering, you waited 2 months, do a second offering, they're considered combined, integrated, and the 35 limit would apply essentially to both offerings now. Instead of 35 and 35 to get you to 70, you'd be limited to 35 because they're integrated. And there's a number of other issues with that. That's the main one I want to talk about today. This went into effect in 2021, and some people, don't necessarily know about the changes to this, but that was brought down to 30 days in between. So now, and along with that, there's commentary and also the rule of 152 that was changed effective 2021. Now, there only needs to be a 30 calendar day period in between. And as long as there is, it's generally not considered integrated. And it is a facts and circumstances. And there's a number of other nuances that I'm not going to get into today, but that's the general rule. 30 days in between, not integrated. They are considered separate offerings. So the SEC also said, well, we don't want somebody to do a quick offering of a couple weeks, bring in 35 non-accredited, wait 30 days, do another couple weeks, 35, 30 days. That's just going to blow past. The whole protection of investors is going to go out the window if suddenly you can kind of skirt the rules as long as there's 30 days in between a 2-day offering. 2-day offering, 30 days, 2-day offering, 30 days. And to get you to 350 non-accrediteds in a year. So they said basically no more than 35 non-accredited in any 90-day period. And that's basically what the rule says now. So you have the 30 days in between, and you have the limitation of 35 in any 90-day period. Now, they also said that you can combine or do concurrent or consecutive offerings. So you could have multiple offerings going at the same time, or one right after the other, as long as there's that 30 days in between. So there's a number of facts that go into that, whether they're the same offering, are you offering something different? So some people try to get tricky and say, well, I'll just do 5 at the same time and just make one little change, and they're totally different, even though they're the same thing, to try to avoid the rules. So you can't do that, but you can have what I'm talking about today is consecutive. One offering, time period, wait, then another offering. So what does that look like? So here's a little chart of, in application, what that would mean, what it would look like. Now, some people do say, well, if it's 35 in a 90-day period, why don't you make the offering 60 days with a 30-day waiting period? That's 90 days, 35 investors. Technically, I don't know if there's any guidance yet from the SEC on that. I guess technically it probably would fit in the rule, but for here, just for clarity and a little bit more safety, I've put 90 days. So you have offering number 1. So the same corporation or LLC goes out and sells its stock, and the first 90 days, they bring in 35 non-accredited investors. Okay, terminate that offering, then they wait 30 days, then they start offering number 2. New set of offering documents. They might be similar to the prior one, but it is showing up as a completely different offering, maybe under the exact same terms. So offering number 2, then you bring in another 35 in a 90-day period. Then you terminate that one. Another 30-day waiting period, 90 days. Offering number 3, 35 non-accredited investors. The terms may be almost exactly the same. So it's really one long offering with these 30-day breaks in between. But that's what the rule allows you to do now. So you do want to make sure a good securities attorney drafts this for you to make sure you're not violating any rules. And in some cases, you could bring it down to 60 days for the offering period with a 30-day waiting period. But again, you need to discuss that with your securities attorney, see what you're willing to do. But that's one way to do it. So within a 1-year period, you could effectively, I mean, if you did 60 days, you'd have 4 quarterly offerings. So 4 times 35, you could bring in, like, what is that, 150 non-accredited investors in the first year. So not a lot of people know about that, but that is one way to do it. You do have to make sure it's done properly, because the second offering, has to discuss, gets a little complicated, but your PPM in the second and third offerings have to talk about what's happened in the company. They have to discuss the first offering. They have to discuss what's updated financials. So there are some things you have to do. It's not as simple as copy and paste of your first offering docs. Usually you need to make some updates to part number 2 and number 3 or 4 or whatever. But the same company can have multiple offerings. Thank you for watching, and make sure you like and subscribe.